Ebusunya Bekaya, Speaker of Parliament, Alban Kisford, Sumana Gbagbin versus Minority Leader Alexander Markin. The upcoming vetting of the new Chief Justice nominee, Chief Justice Baffoe-Bonnie. Here's some kids of Parliament. Now, who could be more Parliament? A minority caucus led by their leader Alexander Markin actually say following court case pending before the ECOWAS court no say betumi a anka vetting committee no entering trend so kosi say ECOWAS court no be determine the case between Chief Justice Gertrude Araba Esaba Tokonu versus government of Ghana following her removal from office as Chief Justice Asebno ECOWAS court no ebetie and I say will sit on the matter on 18th November 2025 we na Afenyo Markins actually mu say sankebe to me the vetting of the nominee and as a nominated Chief Justice Chief Justice Baffoe-Bonnie no and Parliament vetting committee in twin so ko ti say ECOWAS court no betie asem no na verdict ebeba no eno achi ansa na kan wetumi akoye sa vetting no na Right Honorable Alban Kingsford Sumana Gbagbin, Speaker of Parliament actually mu say so what my kwan say legal suit to be blockade Parliament from undertaking its core mandate enye ade ebeboa enuti no so kaso obaji Afenyo Market asem no kana to mu a enye enuti no he did not grant the request by minority leader to hold on with the vetting of Justice Baffoe-Bonnie until the ECOWAS court determines the matter before it no one fa anye juma then no Afenyo Market
there is no constitutional or standing order basis for Parliament to hold the process simply because there are pending cases in court. Should I accept that argument, it will mean that any litigant could hold Parliament hostage, that is, file a case and freeze the work of Parliament and its committees. The motion is inadmissible. And same has been returned to the sponsor, the minority leader, Honorable Alexander Afenyo Markin, as stated clearly by outstanding orders.
The ECOWAS court determines the matter before it no. One fa anye juma. Then Afenyo Markins other reactions be eba ya say ekutie. Afenyo Markins also the side of reactions are by following the decision by the speaker to disallow their request to hold on with the vetting of Justice Baffoe-Bonnie. Ebusunya, Eguti Afenyo Markins argument on the floor of Parliament concerning the matter on hand enya asem kitwa. Make sure you subscribe here. Kindly subscribe to Unsika TV. Not follow on Facebook, TikTok, and Instagram for latest updates. Afenyo, feel free say bachelor wagi na person say mama in the comment section.
Mr. Speaker, according to the majority leader, there is going to be vetting. And the chief whip attempted to arrogate the full powers of this House to himself, as if we are dealing with a one-man power, show of power in this country, by saying it will happen, it will happen. We are not into blows. We are here to argue law and for you to determine. So this kind of attack that it will happen, we argue for posterity. Democracy and practice is for posterity. So they should take it easy. Mr. Speaker, let me draw your attention to detailed provisions in our orders. First, Order 2172 on the sub judice rule, Order 103F and 123.1, and on the Speaker's control of the business of the House, guided by Order 2164. Mr. Speaker, none of these expressly contemplate the coexistence of an active constitutional dispute over legality of vacancy. The vetting that is being announced seeks to fail. We have a situation at hand. One is procedure under Order 217 that empowers the appointment committee to consider a nomination when existence of the vacancy itself is sub judice. are we going to do that? That the appointment committee, knowing that there is a sub judice matter, will still proceed to consider the vetting, whereas the Constitution itself contemplates that the office of Chief Justice will never be vacant. That is why, even when the woman was originally suspended, there was an acting Chief Justice. So there should be no hurry. Nobody should contemplate that Parliament is somewhat stopped. That seat is not vacant. However, proceeding to vet a new person to fill that office will be rendering the application of Justice Gertrude Esabatokonu odious. Mr. Speaker, the second is constitutional. We would be proceeding on the part that would amount to a legislative interference with judicial process, contrary to Article 1253 and 1272. Mr. Speaker, which vests judicial power exclusively in the courts and oblige all state organs to protect their independence and effectiveness. Mr. Speaker, we have under Order 20 of our rules, 24 provides the Speaker is the head of the institution of Parliament and presides over the sittings of Parliament. 4, the Speaker shall A, uphold the honor, dignity, and the sanctity of the House. Mr. Speaker, if you read this provision in conjunction or together with the relevant provisions that protect the independence of the Constitution, we are being called upon, therefore, Mr. Speaker, to ensure that Parliament is never seen as bringing any other state organ into disrepute. You sit there, Mr. Speaker, have a duty to uphold the honor, the dignity and sanctity of the House. If this whole Parliament, in view of its own precedents, not long ago, in March, when Afenyo Markin and Habib Idrisu and Vincent Assefa had an application, which application was to determine a governance and practice issue, the majority leader argued strenuously that indeed that matter has a constitutional arm, had a constitutional issue attached thereto. Therefore, I should be restrained from moving the motion. Mr. Speaker, that was his contention. Much as Mr. Speaker, much as I argued that the matter before the House had nothing to do with the court matter, because the House still ruled. By your very good self, Mr. Speaker, you presided. Mr. Speaker, you presided and told us that indeed, because the matter was before courts, we cannot take the motion. Mr. Speaker, let me refer to Eskime, the 5th edition, Eskime, the 26th edition, Eskime, paragraph 2011, I quote, "The House has resolved that no matter awaiting adjudication by a court of law should be brought before it." The matter, if the matter is awaiting adjudication, this House must stay its hands. That is the law. That is the practice. Mr. Speaker, how then would the majority leader, in coming with a business statement, invite us to accept as part of the business statement the vetting of the nominee on Monday the 10th of November, when he is aware that the ECOWAS court has scheduled the 18th of November for the ruling in the matter brought before it. What does this House want to hurry to? Why are we in a haste? To render the outcome of the case nugatory, otious, to deny the woman, the Chief Justice of the Republic, her right to occupy her office?
Honorable Minority Leader, kindly conclude.
Mr. Speaker, it is public knowledge that the learned Attorney General has so far even refused to file a defense in the matters at the Supreme Court. It was only last week that he filed a motion for leave to file for extension of time to file. Mr. Speaker, all these are happening in this country, a country of rule of law, and Parliament would want to shut its eyes on this. Mr. Speaker, in any event, the man empowered with the mandate to empanel the court is himself the very person who has been nominated. And so far, whereas he was in a hurry to empanel the court to hear the injunction applications, none has happened in any of the 6 cases. Mr. Speaker, there's a High Court matter where the Justice Tokonu challenged the warrant of a removal. The AG filed an application seeking constitutional interpretation. It's been weeks that my Lord Baffoe-Bonnie, who alone has the power to empanel the court, has not empaneled the court. In fact, none of the cases involving my lady Tokonu, as well as our respected colleague Vincent Assefoa, has received the blessing of the court for the purpose of hearing. Meanwhile, the time for hearing has long lapsed, with the AG not filing any process and now seeking the leave of the court belatedly for extension of time. Mr. Speaker, I dare submit that the man who is going to be nominated himself is conflicted. He is in conflict. How can you, who knows that that office, the occupant, is being denied her human rights, and you are supposed to empanel, you are refusing to empanel, yet this House should bless you with the benefit of vetting. Mr. Speaker, the majority leader cannot invite us.
Honorable Minority Leader, I'm pleading with you to conclude.
No, I'm concluding. Mr. Speaker, these are preliminary matters. We have our own matter to deal with, but we want to bring it in the context of the Business Committee report and invite the majority leader to graciously withdraw that aspect of his submission to the effect that on Monday there's going to be vetting. We will not support a report, that business committee report, that has an aspect that says that there's going to be vetting. Mr. Speaker, in any event...
Honorable Minority Leader, do you have the business statement?
Mr. Speaker...
The business statement
Mr. Speaker,
report.
With respect, the business statement, when a member... Mr. Speaker, I've been a majority leader before. When the business statement is presented and questions are asked, and inputs are made, and the majority leader and leader of government business, and for that matter the chair of the business committee, confirms certain provisions, it becomes part of the report. That is it. Yes. So, Mr. Speaker,